Welcome, everybody. This is Brian Terrian from the Disability Digest with a special event for you all about Social Security disability hearings. What you need to do to prepare for your hearing, what's done to prepare you for your hearing. Now, hopefully, if you're watching this, you don't need to go to a hearing and you win your case early, but that doesn't happen with everybody. So we have two special guests here to walk you through the process. Miss Carl Del Rosario,
Hi.
hi, Carl,
Hello.
and Mr. Michael Sexton.
Hey
So
everyone.
yes, great to have you here. So the process that we have here at the Disability Digest is Curl does a lot of the case preparation work that you'll hear about, and Michael works with these cases when they go into the courtroom or are done virtually. So that's what you're going to hear about today. So hopefully this will give you some clarity on what goes on, reduce your stress level, increase your ability to be prepared. At the end, we will point you to some additional resources that you will find helpful. All right. Okay, so first of all, Carl, I would like to learn from you and have you share with the audience, like, what is the preparation steps that you do to get things ready for somebody like Michael to review? And just for everybody's understanding, this is the format that we use. It's a pretty common format with other individuals that represent cases. It may, if you have somebody else, maybe you're going to learn something, but they might not do it exactly this way. But it'll help you understand what should be done. So, Carl, what can you share with us?
So, hi. So, for the hearing steps that we follow here in the Disability Digest, we start on checking the notice of hearing. We then send the hearing preparation to our clients. This contains the medication and the doctor list. We request all the medical records on the list that is provided, and we introduced the client to the lawyer so that they could run through all the process and what to expect and what not to expect on hearing.
Mm-hmm.
And then after that, we upload all the documentation, sorry, for 10 days before the hearing. And yeah, so that's how we complete the pre-hearing information for our clients.
Quick question, Carl. It could be an attorney or non-attorney that we prep, right?
Yeah, that's
Um,
correct.
we'll learn more about that in a minute. What are some of the documents that are prepared? Like, can you just spend a moment on the medical piece? Like, what medical information is collected, gathered, um, and included?
So all right. So we have the medical records that on the doctors that the client sees.
Mm-hmm.
Um, we also have the doctor support forms. So this would be very helpful as evidence to present to the judge as well.
Right,
So,
right. And for those of you listening out there, at the initial application stage, Social Security does request the medical records. So, for example, let's say you have 5 doctors when you first apply, then it's their responsibility to get those medical records in. But after that, let's say you've accumulated 2 more doctors after your first denial, those records are not going to be in the system, and nor would they have any updated medical records from when they first requested. So the job that Curl does is to fill that gap of medical information. So thank you, Curl. That's very helpful. All right, Michael. Uh, You've got a great background in doing this. It is a pleasure to work with you. You are definitely in it from my experience over 18 years of meeting people doing this for the right reasons. And I don't want to proclaim that I understand your entire bio or attempt to communicate it. So I would like for you to do that, like a little bit about your education, your background, like you practice this area of disability, for what reason. So help others understand like your story.
Yeah, well, thanks for bringing me on, Brian. And my name is Michael Sexton. I graduated law school at Michigan State University. I was probably the only person at law school who was actually practicing and representing clients at hearings while I was going to law school, which did not make for a very easy law school experience. However, it did thoroughly train me, better prepare me to come out of law school and represent clients. I probably averaged 100 hours a week, especially in my last couple of years. It
Doesn't
certainly
sound
was
like a lot of fun.
no, I did not have much time for fun there. Following law school, I had two options. So I am a what's considered a non-attorney disability lawyer or non-attorney disability representative. The reason for that, my two options, I could one take the bar exam, which contains absolutely no information or testable information on disability or really Social Security in general. And the second one is called a EDPNA exam specialized for Social Security disability. And my goal in coming into this field was to specialize as heavily as possible into this field. I want to be the best representative, especially at the hearing stage, that I can possibly be. I have no desire to practice any other field of law, bankruptcy, tort, contract. I just want to do this and be the best that I possibly can be. We're very gone from the days in which you had to go with whatever attorney or lawyer or rep was local to you, and he might be, he might dib and dab into 10 different fields. Now you really want a specialist in whatever legal field that you need representation. What got me into this field originally, I grew up with a very disabled mother. She suffers from a rare condition called arachnoiditis, and it is incredibly painful and incredibly debilitating. It actually used to be an automatic disability. They changed that a little bit. They removed it as listing. It's no longer, but it is certainly motivated my passion to get into this industry and really help all the claimants applying for disability. My mentor and aunt, Patty Sexton, a very well-known representative in this field, took me on very early on in my law school career and really taught me the ins and outs of this field. A second mentor of mine, Karen Starr in Michigan, she was a vocational expert who actually worked for Social Security for about 20 years. And she brought me on while I was in law school to essentially to write up vocational evaluations for the attorneys that, especially the big firms that go to hearings. And this is a level of training and knowledge that most attorneys and reps never get the chance or opportunity to get a hold of. So it really was invaluable to how I came about starting off having higher percentage rating outcome approval outcomes than a typical attorney or representative in this field. It's invaluable to how I go about practicing and to strengthening a case.
Mhm.
Following law school, I started my practice, Spartan Disability Advocates, and specifically chose the name Spartan Disability as kind of an homage to the hard work that Spartans underwent. In my opening law school ceremony, we had one of the state's top defense attorneys give a lecture. He essentially told us that pound for pound, hour for hour, we would never beat him. He's too good, skilled, knowledgeable, too experienced. However, we can outwork him. And I've really adopted that type of mentality, that mantra into my practice and how I go about representing clients, especially at the hearing stage, which is, as Brian's mentioned, kind of in many cases, the last ditch effort on this path to getting stability in your life. I will let you in on some secrets that most attorneys and representatives do not want you to know. We will start with a simple math problem. Attorneys charge $300 per hour, and the going marketplace rate for a contract attorney at the hearing or representative is $300. How many hours, if it's $300 per hour and the cost in total is $300, how many hours do you think an attorney is going to spend on your case? because I spend a bare minimum of 12 hours on each and every hearing. And this is not an insubstantial amount of time. And Brian and the other representatives and attorneys who contract my services, they pay a substantially above market premium to have me on board. If another attorney does not write a brief or writes a one-page brief, I write a 10 to 12-page brief submitted to the judge.
Mm-hmm.
If they don't deliver an opening statement or just pull one off of the cuff, which I've seen many times, I deliver a 2-page opening statement that is very concise, and I really use it as a roadmap for if I were a judge, how would I go about approving this case? I want to give the judge every opportunity to approve this case that I possibly can and minimize the amount of work and mental effort that it takes them to do so.
Mm-hmm.
So with all of this being said, I've obtained an incredibly high success and approval rating as a result of this level of hard work. And you need to know that not all representation is equal. And Brian and I, we approach every case as if it were our own mother or another family member who is in desperate need of help from us to get their life back on track and get that level of stability that they so desperately need.
Mm-hmm. Yeah. Well said. I thank you for sharing that. And as you are explaining it and the great work that you do, I see it appears to be your degrees are up on the wall there, which is great. So nice of you. And one of the key takeaways that I was listening to is you worked for somebody else in this industry, like you followed somebody's success path. And
Yeah.
when individuals are seeking their disability benefits, they oftentimes get led on like a wild goose chase of listening to a channel over there or this or their brother-in-law. So one of the key things is make sure that, like Michael did to learn and hone his craft, is that you stay focused, right? So that's key. Thank you for sharing that. And again, I appreciate the great work that you do. Now let's get into some of the finer aspects of a hearing. I don't know if finer is the right word, but we're often asked about the hearing types, Michael. And, Curl being on the front line would deal with these questions like, okay, so I received this form, I have these hearing options, like, what should I do? You can like do it in person now, you can do video, you can do phone. What's your experience? What's your suggestion, or do you have one?
Yeah, well, since COVID, before COVID, they only allowed in-person hearings. Since COVID, that's all changed in a very dramatic way. Now they allow the video hearings, the telephone hearings, and they're actually going to cement that into the federal registrar come November. Now, in my experience, I've had much better success rates with telephone hearings for a couple of reasons. In a in-person or video hearing, if you are alleging especially physical conditions, say you state that you can only sit for 10 or 15 minutes at a time. Well, not only do you need to be concentrated on answering the questions that I'm asking, on staying focused on the hearing and what the judge might be asking, not messing up and giving incorrect testimony, but now you also need to be watching a clock. And you need to be saying, all right, at 15 minutes, I need to stand. 5 minutes after that, I need to sit, and vice versa. You just keep going through that whole cycle. Or maybe you're making positional adjustments to the left at 2 minutes, positional adjustment. It's overwhelming and taxing on your brain already just doing the hearing. And this is something that you don't need to be worried about. And this is something a judge will use to deny you. If you say you can only sit for 15 minutes and you get nervous and anxious, which we see a lot, and you sit there for the entire hour-long process, well, the judge is going to put in that denial letter. She states this, however, I sat there and watched her sit down without seemingly any discomfort or necessary positional adjustment for the entire hour-long process. So rare instances, in person or a video hearing might be better, but most of the time telephone. And if you're under 50, always telephone hearing. especially if you're way under 50. If you're like in the fighting age category, 20s to 30s, you look like an able-bodied person, whether or not you are. Definitely telephone hearing.
Well said. So what I am hearing, no pun intended, is that you remove a presumptive opinion from the judge based on your appearance, posture. That's all gone. It's
Yeah,
just we're talking about evidence, right?
yeah, evidence and testimony. That's all we want to have to worry about. Anything
Okay.
else is just more factors that could potentially result in your denial. Anything that we can eliminate that might do that, we need to.
Okay. Okay. That's really helpful. So phone hearing, go for it. Is there any options where somebody could not have a phone hearing that they would be forced? Does that happen?
Very rarely. So this has been quite an issue as of late. Some judges, and I've only seen this happen about twice, some judges are requiring in-person hearings. I have to fly to Minneapolis here in about 2 months because one of my client's judges is demanding an in-person hearing, and we've objected and we've submitted timely objections, stating she lives an hour and a half away from the hearing office. This is very unreasonable. And the judge is demanding an in-person hearing nonetheless. Now, with the recent federal registrar change, and I am a little bit concerned about this, we are not going to be allowed to object to in-person hearings going forward. Uh, we, the way that it reads, if when we're choosing the actual hearing format, we have the option still to choose, in person, telephone, video. But say it accidentally gets scheduled as an in person, I don't think we're allowed to object to that.
Wow. All right. Good to know. All right, let's move to the hearing environment. Like who does what at a hearing. I want to preface this by like, uh, do the same components of who does what at a hearing exist for the different types of hearing? Like, you have a judge at all, right? But all the other
Yeah,
ones. So,
yeah,
right.
procedurally, they're all the same.
Okay. Okay. Good answer. All right. So help us understand, like, because I think this is where a lot of people get intimidated by, oh my God, what's it going to be
Yeah.
like?
Yeah, well, when I go into a hearing, ideally the day before, I try to run very thorough hearing questions with each claimant. Uh, and, again, if another attorney or rep spends 30 minutes, I might spend 2 hours. I want to get you as well prepared for this hearing as we possibly can, as well as have as much control over the structure and format of the line of questioning that I'm going to be asking and the answers that I'm going to be receiving. So the way I kind of go about doing that, I start off by explaining really the procedures of the hearing. So procedurally, pretty much always the same. It might vary a tiny bit. The clerk will call me, and then the clerk will call you. They'll ask if we're ready to proceed. We always say yes. The clerk then gets the judge and vocational expert on the phone. The judge comes in, usually very straightforward, just says on the record. They introduce the parties, and then they swear you as the claimant and the vocational expert in. That's the standard. You swear to tell the truth, nothing but the truth. Oftentimes, they will ask a series of personally identifiable questions just to verify you are who you say you are. And that's like, what's your date of birth, social security number, address, name. And then the judge and I run through really kind of the procedural issues in the case. Are there any outstanding records? Are they material to the outcome, or can we try to waive those outstanding records? Are there any files by mistake in your records that I need to object to? Typically not. Typically neither of those are the case, but it does vary case to case. I deliver as I mentioned earlier, very lengthy opening statement, often summarizing really the best arguments in the case, highlighting the best medical evidence, and giving specific citations, again, just to make it as easy as if I was writing an approval decision myself. I wanted to say, here is why they're disabled. They meet this listing. Here's the medical evidence that substantiates it. Here's the doctor's opinions that substantiates it. Here's the functional limitations, the symptoms they undergo, and here's the exact citation to each and every single one of those within the entirety of the record that allows you to issue this approval right now. And it's strong enough of an opening statement that I often actually have quite a few hearings where, following the opening statement, the judge will just turn it straight to the vocational expert without even asking questions, and just saying, all right, I agree with this. Let's go to the vocational expert. Let's end this thing.
Michael, I have a question for you, if I could pause you here. Really helpful, but I want to help the audience understand two things that they may not. One is, we talked about a brief, the extensive brief that you write, and then this piece with the opening statement. So would it be possible for you to give an example of an opening statement and how that may tie into the preparation work in brief that you did? Excellent. Let's do it.
Yeah, so opening statement typically looks like such and such is in the, and I state what age category you're in, younger or advanced age category. They suffer from many disabling conditions or impairments, including but not limited to, cervical radiculopathy, lumbar spondylitis, neuropathy, migraines, headaches, whatever conditions you might suffer from. And then I jump straight into, do they meet a listing? Often it's like listing 1.15 or the more mental type listings, listing 12.04, 12.05, 12.15, or do they meet a grid rule? Those are the two things that a judge, in my opinion, really wants to know right off the bat. And I do always put these in the brief as well. So what I do is I take that 10 to 12 page brief and I condense it into, what does this judge really need to know in a 2 to 3 minute time frame? How can I deliver that in which it's the most impactful and it has the most effect upon the case, the outcome of the case? And from there, running through all the different citations, all the different medical evidence and justifications for why they should be found disabled. And often I'll run back through kind of on the back end into more of the step 5 analysis, which is, can you do any job that exists in the national economy, or can you do any job that is substantially similar to the past work that you have performed?
Mm-hmm.
And I really run through, RFCs or positional adjustments required. Why are they going to be off task? Why are they going to be unable to interact with others? I try to what's called substantially erode each occupational base, and specifically the sedentary and light occupational bases.
Okay, that's very helpful. Good for you. Let's continue. What are some of the other hearing expectation? Who does what?
Yeah, so following the opening statement, one of two things will happen. Either the judge is going to start asking you questions, or more than often, the judge will just ask me to begin the line of questioning.
Mm-hmm.
The questions that I ask are always questions that we have ran through the day before. So they're questions that I generally know the answer to, and they're boiled down questions. So on the day before, I throw everything against the wall, see what's going to stick, and then take everything that sticks, go into a more detailed analysis with you on that day of hearing prep, and then bring it up at the hearing and run through, all right, so you've had this difficulty at your past job because of this reason. What other difficulties or what other environments have you experienced that difficulty with since trying to do that job? And we run through, really, I try to pick apart every issue that might result in your.
Mm-hmm. Okay. So you're asking the claimant the questions to help the hearing room understand the qualifications, right?
Yeah, exactly.
And is there a time when the claimant is asked questions directly by the judge? Or
Yeah,
okay.
yeah, that pretty much happens every single hearing. Usually the judge limits their questions to more specific, like what does an average day in your life look like from the time that you wake up until you go to sleep. They are designed to kind of trip you. And that's why I try to run through those really thoroughly with you on the pre-hearing preparations, ideally the day before.
Okay.
It's easy to get tripped up on those. And frankly, they're kind of hard questions.
Yeah, and at the end of this event, we're going to provide you with a link to how you can learn about more of what those questions might be. Okay, this is great. Let's continue.
Yeah, so following the questions that I or the judge ask, it gets a little bit confusing, but your part in the hearing is essentially over. It turns to the vocational expert. The judge will ask the vocational expert a series of hypotheticals that are sound incredibly confusing. You're going to be completely lost at this part. Everyone always says, I have no idea what happened. The judge is going to say things like, hypothetically, if they were limited to occasional stooping, kneeling, crouching, crawling, superficial or occasional interaction with coworkers and supervisors, no interaction with the general public, standing and walking for 6 out of 8 hours a day, a whole host of hypotheticals, maybe simple routine instructions, simple routine decision making. So the vocational expert almost always comes up with 3 jobs based on the first 2 hypotheticals that they think you could be performed solely based on that hypo. The third hypo is typically work preclusive. So the judge might ask if they're off task 15-20% of the day, if they're going to miss 3 or 4 days per month, absenteeism, off task behavior. And then I come in after all of that and I cross-examine the vocational expert with a series of hypotheticals that I've created really based on what the record shows and what your testimony shows. If you have urinary frequency or incontinence, you need to go to the bathroom, once an hour and it lasts 10 minutes. I'm going to come in there and ask a hypothetical basically structured on that exact thing. Could they perform a job that exists generally in the national economy based on this specific limitation as which is outlined within the records and the testimony? And it's very good not only for cornering the vocational expert into saying, no, there are no jobs, but also cornering the judge into saying, well, I could issue a denial, but it's going to be appealed, and it's likely going to be appealed based on that vocational expert's statement that based on this limitation, as which is outlined in the record, could not perform a job. And that's pretty much what the whole hearing looks like. It typically lasts about 40 to 45 minutes, usually no longer than an hour. I have had one go over 2 hours, and that was not my favorite judge. Usually 40, 45 minutes.
Okay, good to know. Good to know. All right, so you provided some real good clarity on what goes on in the hearing. And talked a little bit about the preparation steps that you do, but I'd like to learn more about what your preparation process is. And again, not everybody is going to have the opportunity to go through this system and have the exact cast of characters working on their case for whatever reason. So maybe it's going to be different for somebody else, but nonetheless, I'd like to get your perspective, and because I know your success rate is phenomenal, and I expect a lot of this has to do with the preparation. All right, so back to you.
Yeah, absolutely. Preparation really is key for anything you do in life, in my opinion. What can you actually expect at the hearing? It really differs by state. Some of them move very fast, some of them move very slow. How long can you expect to get to the hearing stage? Me and Brian have a lot of clients in Texas. When I take a new client, especially if I'm doing an initial filing and I expect them to go to hearing in Texas, I let them know, it might be 3.5 years. Whereas here in Kentucky, it's going to be a year, probably at most. 12 months is pretty typical to get to the hearing itself. So it differs dramatically by state. Now, what the actual process looks like. So I always call about 3 weeks to a month ahead of time. I just want to make my introduction with you, let you know kind of what to expect, what the next 3 week, month-long process is going to look like, and kind of to mentally prepare for that. I also like to call early just to help kind of put your anxiety at ease, let you know that you're in good hands. This is a very structured process, and while you are very nervous about it, and understandably so, we are doing our utmost to be on top of everything that we can possibly do. One of the things to do to kind of prepare, I mean, there's no specific preparation aside from maybe, working with us. Cooperation is key in this process from really the beginning. And cooperating with us and letting us know what medical evidence you've obtained, what medical treatment you've gotten since maybe last letting us know. If there's any new medical treatment building up to the hearing, oftentimes there is. That we always advise, go see a specialist if there's someone you haven't seen. Get as many medical appointments as you can, and really let the doctors know what is going on. Don't tell them you're okay. Number one problem I see, they go all these doctors and they just tell them, oh, well, I have severe depression, but it's pretty good. And, well, we can't win a case if it's pretty good. It looks well controlled by the medication. You need to tell them what a bad day looks like.
Yeah. Some personal pride there for sure. What about the hearing environment is going to be different if it's in person versus at home. But if it's in person, what's expected for attire at home, I don't expect it matters, but what's your perspective on that?
Well, certainly, and obviously via telephone hearings, there's no expected attire. Even for me as the representative, there's no expected attire. For video and in-persons, this is a non-adversarial process, which means it's very different than another court proceeding. They don't expect you to be in, you're a disability claimant. They don't expect you to be in a suit. They don't expect you to be in any type of business outfit. I, as a representative, absolutely expected to have that. But yeah, it's a very laissez-faire, and the judge makes it known from the beginning. This is non-adversarial. This is not, the rules of evidence, the civil rules of procedure. They are all suspended in this proceeding. They do not exist or null and void.
Just want to mention this, that if it's a phone hearing, I think that it's important to not be going through the drive-through at McDonald's while on your phone. Yeah, right. So you just want to be in a quiet place. You're expected to be in a room by yourself, right?
Yeah. I always call an hour before the hearing and I let you know I'm going to make sure your phone's working, make sure your ringer's on, and make sure that you are in a room by yourself.
Yeah.
Completely focused, not distracted, and ready to go for this thing because it is important.
Yeah, right. No, very helpful. I want to just circle back a little bit to the hearing questions, and again, we'll provide a list of questions that are commonly asked at a hearing. We reviewed I don't know how many hearings and took the hearings questions that judges asked and put them in a course for you. But what can you speak to, like the types of questions? I expect that there's physical questions, mental questions, questions about, like you mentioned, daily living. I'd like to learn more about that. Share it with the audience, if you would, please.
Yeah. And I would highly recommend viewing that list of questions. It's a phenomenal list. Brian and the others put a lot of time and effort into that thing, and definitely take a look at that. But I mean, as a general overview, all the questions really boil down to kind of one or two things. And if you take anything away from this, this is what you really need to take away. This is super important. Every question is going to boil down into the length, frequency, and severity. So I'm going to ask, so you have back pain and you have difficulty standing and walking. How long does your back pain last when it starts? How often does it occur? And how severe is it? Or, for example, numbness and tingling. Say neuropathy in your hands and wrists, radiculopathy. When you have numbness and tingling, how long does it last when it occurs? Is it a minute? Is it an hour? Is it the entire day? Is it constant? What is that frequency? Is it every day, 5 days a month, 5 days a week? That's very important. And what is the severity? I mean, can you still use your hands, but it's just a little mildly annoying? You have some pricks and tingles here and there. Are you not really able to use your hands at all? Can you not even wash a dish?
Mm-hmm.
Every physical or what we call RFC question kind of boils down to that. The two general lines of questioning being the physical and mental, or physical, mental, and cognitive. So for all physical questions, they boil down into what's called an RFC, or a residual functional capacity question. And that is, I mean, that comes down to how long can you stand and walk for? How long can you sit for before you have to stand up or lie down as a result of pain? How well can you use your wrist, hands, fingers? Really just all of those different areas of physical functioning that a typical job or vocational environment requires. And then for mental or cognitive questions, they all boil down to what's called MRFC, or mental residual functional capacity questions. And they really boil down to how well can you stay on task? Do you have difficulties concentrating, maintaining persistence or pace? What about interacting with others? Do you have explosive outbursts on others? Do you have crippling anxiety and can't be around strangers? What about understanding or remembering information? Do you have memory issues? We see this a lot with even just like physical pain, because you're in crippling pain like that. Well, it affects your memory, your brain's capacity to store information and to retrieve information. So all of them really boil down. And then the last one, which is a little trickier, adapting to changing circumstances.
Mm-hmm.
That one's trickier and is going to be more on a case-by-case basis.
Mm-hmm. One thing I just want to perhaps remind people of is when you ask a question about like, what's it like, or how long can you stand for, and that the response that you receive, the ideal response that you should receive would be something that is clearly measurable, like 15 minutes.
Yes.
Or lifting. If you say I can't lift or I can't walk for a long time could be not a long time. I mean, it's not definitive. So be very careful about your responses to the questions, or have them prepared. Know your case. Yep, that's excellent.
Yeah, if I might jump in, two things really quickly on that. One, don't over exaggerate your symptoms. I mean, when you run through that line of questions, if you over exaggerate, the medical records show something different, they're going to deny you for it. They're going to say your testimony is inconsistent with the record. It's not reliable.
Yeah.
And then the second thing, I mean, really start thinking ahead of time about all of these. Get an idea, maybe chart it out. And, I know Brian's very good about recommending this to all the claimants. Make a list going down this line of questions and bring it to your doctor. It's very helpful if it's stated in the medical records and your doctor knows about it, not only to be able to show that you, in fact, meet the criteria for disability, but also for them to be able to better treat you.
Exactly. Yeah. Well said. All right. So we've gone through some of the key components of a hearing, and the hearing, let's roll it forward. The hearing is done. You're walking out or hanging up or whatever the deal is. And I expect that you get the question like, how'd I do? how'd it go, right? So what expectations can you set for people post-hearing?
I always tell everyone that I'm going to give them a phone call right after the hearing. And that's to basically explain, how the hearing went. If there's any issues that need to be addressed, sometimes there's post-hearing issues. Maybe we need to get some pay stubs if you've been working, or if they're not 100% sure about which day you stopped working and the onset date that's being alleged. Maybe we need to get that. It's not super common, but it does come across my desk, and I see it pretty often.
Okay.
I always tell them, there's only so much that we as a representative or attorney can do, even the amount of work that Brian and I put into our cases. However, within that spectrum of only so much, there is a lot that we can do. So I always advise, be very cautious about which rep or attorney you pick. Not all representation is equal. And, the most important thing, stay in treatment. You know, you need consistent treatment as medical evidence to show the severity, frequency, and length of your conditions and symptoms. Without that medical evidence, I always tell people, if it's not in the medical records, it doesn't exist. And no matter how many times you tell your doctor or tell the judge, or state it on a functional report, if it's not in the medical evidence, it does not exist.
Yeah, well said. Yeah, it's the only way that, as emotionally attached as one might be to their situation or condition, is you've got to be able to prove it, right? Yeah, good. Okay, so we're done the hearing. You've had a follow-up call. That's what you do in your particular practice. And now we're going to transition back to Curl, because there are some post-hearing steps that you go through, and what you do, what you're looking for. So please share.
So for the post hearing that we follow, we send the email to the client. We ask how the hearing went. Also, we receive the feedback from the lawyer to follow up on required documentations
Mm-hmm.
from the judge. So the lawyer may also provide additional supplemental information the judge may require as well. So after that, we wait for 60 days for them to make a decision. So yeah, that's the steps that we follow.
Mm-hmm. Yeah, the only exception to that would be the slight if they make a decision right away, but it might still, which is called a bench, but it
Yeah,
still could take 60 days. Yeah. And sometimes there are things that need to be done on your side, Curl, post
yeah,
hearing. Like,
yeah.
yeah, tell us
Sometimes
about
they require missing medical records for us to send to them.
that. Mm-hmm.
So sometimes they would give us a deadline, and then sometimes they would also require another hearing after the hearing that we had. So yeah,
Yeah, supplemental hearing. We hope not. We hope it's like one and done, right,
Oh yeah.
Michael?
Yeah, we
Good.
definitely.
Good. So we've covered a lot here today. We've learned about your experience and the great work that you do and walking people through like all aspects of the hearing from our perspective. Pros and cons, the hearing type, telephone hearing stood out. Who does what? We learned about your brief and the opening statement, which are key parts of that. And then hearing preparation, like what one should get for hearing hearing preparation, because hearing preparation is key. And then the questions. So I did say during the show that we will share with you in and around this video replay, you can look for a link to disability hearing preparation. So what we did is we listened to, I don't remember how many hearings, Carl, but we extracted 96 different questions that were asked. These are the questions that Michael would hear when he's in a hearing. So you'll get the list of questions and general guidelines on how to answer these. And these are not areas of questions that you have not seen before. Most of these questions come from some of the original early forms that you have filled out when you started your disability application, like your daily living and your work history. There's questions that are derived from there. So anyway, this has been fantastic. I hope the audience out there enjoys it. You're welcome to give us your feedback. We'd love to hear from you. Carl, thank you very much for your contribution today and your
Thank
hard work
you.
preparing all of this for representatives like Michael who do your excellent work and
Thank you.
help our members win and many others. So wishing you both continued success and thank you again for your
Thank
contribution
you
today.
very much for having me, Brian.